everyone. Welcome to Thorough Newspaper Analysis, which is brought to you by LawSikho. And again, we will be discussing the important articles and editorials that we have from the Hindu and the Indian Express. This newspaper analysis is really important, keeping in mind the Judicial Services exam and the law entrance examination. Let's see what articles we'll be discussing today. So today we have a long list of articles and they are really important. Though in some or the other way we have already discussed them, but the additions that have been given in today's articles are of great value, and thus we'll be discussing them all of them in detail. Firstly, make the right call on Malabar going quad. Very recently we talked about the Malabar exercise, which is conducted between USA, Japan and India, and recently India has also made an invitation to Australia to join in, which actually will become the same composition as of the quad. We will be discussing about it and what does China have to say about it. Secondly, why a separate anti-torture law? This is basically about the custodial deaths and the police torture, which is a very, to say, a rampant procedure which is being taken by the police recently. And thus, do we actually need a separate anti-torture law, or are the provisions that we have already with ourselves in the IPC or CRPC enough? So we'll be discussing about that. Thirdly, unshackling for self-reliance. This is a very beautiful article which talks about being Atma Nirbharata or the self-reliant one, which we have recently proclaimed to become, and the very important role that agriculture has to play within it has been discussed. A very similar article has also been discussed by us itself in our newspaper analysis from 6th of July. This simply can be considered as a continuation of that, and in what way we will be seeing in this article as well. And fourthly, isolating the dissenter. This actually talks about the bail, the procedure, and basically the grounds on which bail can be granted and the grounds on which bail cannot be denied as well. So this has been a very recent issue, and bail, granting of bail has also been talked very rigorously these days, and thus we'll be making a discussion about that. These two articles are from the Hindu and the other two are from the Indian Express. And finally, we have the News and Flash column, which is the LawSikho's initiative, wherein we talk about the crisp and small news articles or news items that are important from a prelims exam, and they can be a very potential question for that value. Here, we would like to give you a small description about the LawSikho courses, as we have already been discussing about the beautiful courses that have been drawn up at LawSikho. We have various courses, as you can see over here also. This is the Judiciary Test Prep course, which is a lot of courses, and literally once you go through it, you really will believe that it is like a lot of the courses. And also we have very good news for all the aspirants viewing this news analysis. If you go and visit our test prep courses from LawSikho, here in the Judiciary, you can download right now the free material, which is very amazingly drafted, and it is completely towards the exam requirements, and that you can get for free in your mail, and you just have to register with us and you can get the free material. So go check it out right now. Then we have various other courses also for SEBI, Bar Hacker, for All India Bar Exam, CLAT, etc. So these are the various courses wherein you can go and enroll yourself, and we promise you that it will be a very good experience for you all. And with this, let's start with the MCQ question that is about the content that will follow today. So your question is, ND 2020 recently seen in news is a first, new vaccine developed for the treatment of COVID-19. Second, new high-yielding variety seed of cotton. Third, a national defense strategy to make the borders more secure. Or fourth, an advanced anti-ship missile developed by DRDO. The answer to this question is somewhere in our discussion for today. Be very, vigilant, be very smart, and definitely you'll be able to answer this. The descriptive question for the day is, India has immense potential in its agricultural sector to make it Atma Nirbharata. Discuss the above statement talking about the import and export potential of India in agriculture. With this, let's start with the first article today. For today, it is make the right call on Malabar going quad. Firstly, let's see that why actually this entire thing is in news. As we just talked that recently, India has invited Australia to join the Malabar exercise along with USA, Japan and India. Very recently, India had a virtual conference with Australia wherein various agendas were set up for the cooperation and collaboration of both the nations. One of the things that came out from this discussion was that India invited Australia to join the Malabar exercise along with USA, Japan, and India. Before we get deeper into this discussion, for more clarity, let's understand that what actually is Malabar exercise. Basically, it is a trilateral naval exercise. Now we know that since it is a naval exercise, it has got something to do with the Navy, and definitely it shall be performed somewhere in the waters. And this water is the Indian Ocean region, or the Indo-Pacific region to say. And this is a trilateral exercise. So for now, only 3 nations are associated with it, as we just said, USA, Japan, and India. And these 3 are its permanent members. It began in 1992 by India and USA, but then was later joined by Japan in 2015. All these points are very important. These are very crisp, should be kept in mind, as it is very recently into news and can be a very potential questions from prelims point of view as well. Thus, it should be known that in which year did it start, and when did Japan join it, and who are the permanent members for now. So currently, USA, Japan, and India are the only 3 permanent members, and it might be a chance that Australia, once Japan and USA also give their consent, also may join the Malabar exercise, and this might, from becoming a trilateral naval exercise, it might become a quadrilateral, which has 4 corners to it. Now, the aim of this Malabar exercise is firstly for the maritime cooperation, and secondly, regional security. Because obviously, if we try to see that the location of India, Japan, Australia, and USA, if Australia also becomes a part of it, it already is a very strategic location, and also if there is cooperation amongst these points, then the entire area that is being covered in this under this maritime exercise would be secured, and better cooperation would be seen here. Next, when we're talking again and again about the Quad, so basically let's see that what actually this Quad is. The full name of this thing is Quadrilateral Security Dialogue, which very commonly known as the Quad. Basically, it is an informal strategic forum between USA, India, Japan, and Australia. As now, if we draw a comparison, the nations in common between Malabar exercise and Quad are same, and just Australia is the one that is absent in the Malabar exercise, which maybe would also be joining the Malabar exercise soon. And thus, there is a chance that this Malabar exercise would soon take up the form of Quad, not actually in terms of the functions, but yes, it would supplement the functions of Quad. And the aim of Quad is military and diplomatic cooperation, and secondly, information exchange. That is why this has been sought by India, that if Australia becomes a part of the Malabar exercise as well, then it would be able to function in the similar capacity as it is functioning in the Quad, and thus it will give an enhanced reach to all of these nations in the Indo-Pacific region. Moving with this, let's try to understand that what actually is the China's viewpoint, because we have been discussing this very rigorously lately, that China wants to develop its influence even more in the Indo-Pacific region, in the Indian Ocean region, in the South China Sea, west side of the Indian Ocean, and all of these similar areas. And in such a scenario, when it can definitely see that the influence of these 4 countries, currently, if you talk about the Malabar, then the 3 countries, USA, Japan, and India, and if it will be joined by Australia, is lesser on the side of making its own advancements, but more on the sides of countering China's growth in this area. Which actually, if we talk diplomatically, then maybe this can be one of the reasons that India is trying to bring into the ambit of Malabar exercise Australia as well, because it will give India a better hand and a better position in this region, where currently China is growing its influence with a very great speed. Thus, according to China, it is seeing the maritime Quad as an Asian NATO. Thus, it is saying that the China is actually equating this Quad with the NATO, which is the North Atlantic Treaty Organization, according to which all of these nations that are a part of NATO actually are one entity, are considered to be as one entity. And if any country which is external of this NATO attacks or tries to make any kind of adversary on any of the member countries, then it would be understood, it would be construed that it is an attack on all the countries. Thus, it is a very huge cooperation that is seen, and China is actually equating this Quad with the Asian NATO, and it says that it is one of the forms of NATO, and then it seeks to contain China's rise in the region. And China says that since China is making more and more influence. It is growing its influence in these areas of the South China Sea or the Indian Ocean or the Indo-Pacific region also. Then it says that this attempt is actually trying to contain or to bring down this rise of China in this region. Then it sees India as countering China in the Indian Ocean region and South China Sea. And then it is also realizing the point that India, because basically, generally it is said that the Indian Ocean region belongs to India. So the highest or the most prevalent power in the Indian Ocean region is considered to be as India, and one of the key reasons is the location of the Andaman and Nicobar Islands, because they give us an extensive arm in controlling the activities going on in the Indian Ocean region. But very lately, China and Chinese vessels have been seen to attempt to come into this area, which was earlier controlled by India. And so China believes that India is trying to take back or keep into control the Indian Ocean region and South China Sea, and for that purpose, it is trying to develop the Malabar exercise similar in the way of Quad. And finally, it is saying that it realizes India's affinity towards USA, which is actually one of the reasons that China is not currently happy with India, because earlier India was considered to be as a swing power. So just like a swing, like it swings back and forth or in an oscillation, it was considered that it is actually swinging between China and USA. But now, lately, USA realizes from its side that India is showing more of the affinity towards USA, which China is definitely not liking. Then, what should India do? Now, in this scenario, what should India do? Because we know that China is very important for us, keeping in mind our economic setup right now, because until the time we do not become Atma Nirbharata, we definitely rely heavily for our imports and also some part of our exports to China, because we know that 14% of India's total imports are actually coming from China, which is very huge and cannot be very rapidly replaced by domestic market. Secondly, if we talk about the border that we have in dispute with China, then also there are a lot of areas from in J&K, Uttarakhand, Sikkim, Arunachal Pradesh, where the border dispute between India and China has been there since a long period of time. And we know that China is a very strong country. Definitely, it can never be undermined. It has huge nuclear power. It has huge economic and military power. And thus, India is definitely not in a position, and it would not even want to have any kind of war coming up from the side of China. Further, to analyze, China is one of the permanent members of the Security Council. It has a veto, and thus it enjoys a very strong position at the global level as well. And thus, India should try to maintain a balance. Now, how can it do so? Firstly, it can acquire strategic capabilities. The author very nicely says in this article that if we are even trying to grow our cooperation in the through the Malabar exercise or the Quad, and even if we are trying even if in a hidden way we are trying to counter China's growing influence in this region, this exercise would make sense only and only if we have the strategic capabilities. Because not unless we are well equipped militarily and through our navy as well and through our armory as well, it will make no sense if we are trying to counter China, because China is a very strong power and has huge resources when we talk about the strategic and military capabilities. An example to this has been given that we need to develop the undersea capability to counter Chinese submarines in Eastern Indian Ocean, because we currently do not have this technology, and if we are actually trying to counter China, it should be done in the real sense and not just on paper. And for that, we need to develop our undersea capability so that the Chinese submarines, which actually exist underwater, we are able to tackle and counter them in the area of Eastern Ocean region, wherein basically the South China Sea and other seas which are very strategically important, they all lie. And finally, we should deal with China with diplomacy, keeping in mind the border dispute, because it is very fresh in the minds of China and India both, and thus any step should not be so harsh and so to say extreme that it actually instigates China to do something which we are not inviting. With this, we are done with the discussion of our first article. Let's talk about the second one, which is why a separate anti-torture law. Though the article is very short and crisp, but it has beautiful points in each line of the article, and it should be read with very due diligence, because it is very important from an exam point of view. And since recently we know that the Ministry of Home Affairs has formed a committee for reviewing and overhauling the criminal laws in India, and though that committee is under some kinds of protests and That is a different matter to be discussed. But yes, when we are talking about the criminal laws in India, the adaptability and appropriateness of these criminal laws in India, at the very same time, the torture that occurs in the custody or the custodial deaths for that matter have been also uprising as a matter of discussion. Firstly, we know that we now very easily can construe that why are we even talking about the custodial death, because there was a custodial death of a father-son duo. Please mind the spelling, it meant to be duo in Tamil Nadu. So in the Thuthukudi area of Tamil Nadu, both the son and the father were actually killed in the custodial death. Let's first understand to know that do we even actually need a new anti-torture law, or do we, to say the legal provisions or the laws that we already have in our hand are enough or not. So let's just discuss that the existing laws and the custodial torture. Firstly, torture has not been defined in IPC. So this also can be a very tricky question from prelims point of view, wherein can be asked that torture has been defined in this section of IPC section, this and this. Some options might be given, so it should not be confused with. Torture per se has not been defined in the Indian Penal Code. Secondly, but the definition of hurt, which is there under section 319 of the IPC, it does not include mental torture. Basically, what happens through torture is it might be some kind of a mental torture or also some kind of physical hurt. Thus, it can be construed and it can be included under hurt, which is defined under section 319. But here also, the mental side or the mental aspect of the torture has not been included. But the courts have already, and they always have included various kinds of torture which constitute to the mental torture, like the psychic torture, environmental coercion, tiring interrogation prolixity, overbearing, and intimidatory methods in the ambit of torture. All in all, we can say that though torture to say explicitly has not been defined in IPC, but still hurt has been defined under section 319, but still it does not cover the mental torture. But adding to this, as a good news, we know that the courts have always included mental torture as a part of custodial torture or any other kind of torture for that matter. Fourthly, voluntarily causing hurt or grievous hurt to extort confessions is itself a complete provision under section 330 of the Indian Penal Code. Fifthly, judicial magistrate inquires into every custodial death. This is under section 176, clause 1A of the CRPC. Thus, we know that we have a lot of provisions which actually try to hit at the custodial torture, and they are in a way to say enough. Again, there is a discussion of some other things that we have in hand, like the National Human Rights Commission says that autopsy or the post-mortem should be done under a camera, so that there is no scope left for any kind of wrong activity or any kind of facts that could be hidden in such a scenario, and thus the correct facts would come into the eyes of the court. Also, in the case of D.K. Basu versus State of West Bengal, it was held that custodial tortures were highly inhuman, and it is also against the right to life and personal liberty of an individual under Article 21. Also, in the case of Neelabati Behera versus State of Orissa, it was held that compensation has to be paid by the state, and state cannot escape from its liability. Thus, we can say that the existing laws are sufficient. Next thing that we need to understand is that when we still have so many proficient and properly drafted laws that can actually work very well in the direction to stop and curtail the custodial torture, then what is the reason that we still are facing this problem of custodial deaths? And it really seems that there is no such law that can actually put down or that can actually contain the custodial torture. And in this direction, due to some reasons, we just thought that the current laws or the existing laws are not enough to put down the custodial torture. This bill, which was called as the Prevention of Torture Bill 2017, came up, and actually it is considered as very vague and harsh. The reasons to it is, firstly, in this also torture was not defined clearly. Basically, if there is a bill which talks about prevention of torture, then torture should be defined very clearly in it. But then again, the definition given in this was very vague and it was very ambiguous. Secondly, it provided for death penalty for custodial deaths. Now, in this scenario, when various human rights activists, they say that death penalty should be abolished in all the situations. And in such a scenario, granting death penalty to the people who are accused, or directly to the accused in such a scenario, or in the case of custodial death, is actually very it is chained up in the colonial era, and it is not showing the advanced mindset of the law framers, and thus this cannot be, or death penalty cannot be, the only punishment that can be given to the accused. Thirdly, it proposed the registration of every complaint as FIR, which actually would make it very grave. And actually, this entire bill is making the whole argument towards the custodial death very extreme. Also, fourthly, there is a blanket denial of anticipatory bail to accused. Now, let's just imagine that the person accused in such a scenario is a public servant, for example, an IPS officer. There might be some circumstances due to which the custodial death might have occurred, and maybe in this case, the accused, that is the public servant, is not really the one who should be held responsible, but still will come under this ambit. And let's just say that even if an IPS officer or other public servant is responsible also, then keeping in mind the ambit of his duties that he has to discharge towards the society, if we make this bail to him, the anticipatory bail to him, impossible, then just imagine that how and in what way will the system of the entire society be kept into balance. And thus a blanket denial and complete denial of anticipatory bail to accused is also very vague. Here, the author has also mentioned some very nice solutions to this issue, wherein, firstly, United Nations Convention Against Torture and Other Cruel, Inhumane or Degrading Treatment, which is also known as in short CAT, should be ratified. Basically, it was though adopted by India, but still it has not been ratified till the date, and the author says that it should be ratified as soon as possible. Also, the author says that the already available laws in IPC and CRPC that deal with the custodial torture and custodial death, they are very much in line with this convention, and thus we do not really need a new anti-torture law for that matter. Secondly, we can implement the already available laws efficiently. Definitely, that is the best thing that can be done for now. Thirdly, fair investigations and procedures to be adopted. Fourthly, better training of police, about which we also talked about a day or two ago, wherein there was an idea of bringing in the National Curriculum Forum, wherein the training of the police officers should be made more uniform and also more efficient. Because basically, if you see the police and also in the entire police force, the constables that actually form 80% of the entire police force, they are the ones who actually are the face of the entire system. And when any contingency occurs, at that time, they are the first person with whom a common man interacts, and they are the one who actually introduces the law, or the first step towards moving towards the law for a common man. Thus, this entire team, or to say this entire force, should be well trained in all the ways, be it the physical tactics, be it handling a situation through mental capabilities and various other things. Fifthly, temptation to use third degree methods should be replaced by scientific skills. Very generally what happens is that the police or the people also say that just thrash this person badly, he'll himself confess whatever he did. This mentality, and to say, we actually think that it is very easy to just beat up a person, to torture that person, and to extract the so-called truth that comes out from him. But actually there should be a manner and another skill, that is the scientific skill, which should be developed and which actually looks more appealing and easier to be used as well. For example, if we have in hand the narco test or various other scientific methods wherein the confessions can be more easily drawn up from an individual, those methods will definitely make it easier for the police to deal with an issue, and so they will not be tempted to use the third degree torture on the accused. Sixth, implement recommendations from various committees on police reform. Now, in such a scenario, it says that we already have a lot of committees who gave amazing recommendations in the direction of police reform. And the latest one was the Soli Sorabji Committee 2006, which actually talked about bringing a model police act, that was a new police act, and so that we are done away with the Indian Police Act, which was brought in 1861. Yes, just imagine that this police act, which was brought in 1861, was brought right after the revolution or the revolt of 1857. And it was specifically and purposely drafted in order to give excessive power to the police, and so that the people who were bringing up such revolts could be suppressed easily. And thus, the spirit of the Indian Police Act 1861 is same, giving the idea of a colonial era, and thus it should not be the same. And herein, when we value so much to the liberty and equality of the people and to the life of the people at large, in such a scenario, Indian Police Act should be refurbished, and it should be brought into the spirit of today's society. With this, let's talk about the third article for the day, which talks about unshackling for self-reliance. Herein, we know that India aspires to become Atma Nirbharata, and thus strong agricultural and food security is the key to it. Definitely, we discussed it in the previous news analysis also on 6th of July, that if any nation is equipped and self-sufficient in terms of food security, then that nation is considered to be very strong, and this is one thing that it should not really depend upon on other nations. Recently, the Food and Agricultural Organization observed an unprecedented high storage of food grains, as we just discussed, and in that lieu also the government has made the food grains available for free of cost to various people in the country who are below the poverty line and other poverty-stricken groups of the country till the month of November. And thus, due to this unprecedented high storage, which actually has reached to 100 million metric tons as compared to the normal of 43 million metric tons, shows the capability of India and the capacity in the agricultural field of India. Then, it can be done through making our exports stronger in agriculture. The entire discussion to this, as the article also has been a kind of continuation, in the earlier one on 6th of July, we discussed about the imports, that how India can depend less on imports and can make it self-reliant. And in this article, we'll be talking about it, how India can grow as a big exporter in various areas to become self-reliant and gaining more, teeth in our agriculture sector. Let's see that what actually agri exports from India are doing and what is the current scenario in this area. Let's talk about the seeds first, as the author also says. It says that we are one of the largest seeds exporter in the world, and also in the times of lockdown and COVID-19, we have been exporting large amounts of seeds through special rails and special trains to Bangladesh and also various other Southeast Asian countries. Then India has the potential to excel as an exporter of seeds of hybrid rice, hybrid corn, hybrid BT-HT cotton, and several vegetables as well, including tomato, potato, and okra. All of these things are something that are used as a staple diet in various parts of the world, and they are one of the biggest, seeds that are in highest demand in the world. And thus, it can be a golden opportunity for India, wherein we can develop this potential to become a huge exporter of the seeds in these categories. And then it has been the largest producer and second largest exporter of BT cotton. All of these points to say might be seeming something that why are we even discussing about it? But whenever a question on agriculture may arise, or the economy keeping in mind the agriculture may arise, this is something very important, because we need to know that what is the current scenario that Indian agriculture is facing. And thus we should know that India has been the largest producer and the second largest exporter of BT cotton since by 2013 to 14. And if we talk about the fertilizers, here maybe we do not have really something to celebrate, because India is a net importer of fertilizer nutrients for almost 2 decades, which means that we heavily depend on imports for sufficing the needs of fertilizers in our agriculture. It says that for DAP and MOP, so DAP and MOP both these are kinds of fertilizers, and for these we might have to remain dependent on imports because we do not have the raw materials in hand. So basically, if we do not really have raw materials, and importing the raw materials is even more expensive, so in that scenario, it is okay that we are importing the DAP and MOP fertilizer. But then again, the author says that, but if we talk about urea, which also is a very most rampantly used fertilizer and is the one that actually suffices the need of nitrogen in the plants. So if we talk about the fertilizer urea, we have already developed 5 new public sector plants that can make a difference. But then again, we have an anomaly here. What is happening is that for the production of urea, we are actually importing the gas which we need as a raw material, but this is again much expensive than the domestically available gas. Actually, for the development of or for the manufacture of urea, we need a particular gas which is rich in nitrogen, and we are currently importing this gas as a raw material to produce urea. But India is also quite sufficient in making or available this gas domestically as well, and thus we should rely more on the domestic resources rather than importing them from the outside. And actually, because of this, what is happening is that we are making urea more costly and uncompetitive, and ultimately from the rate at which we were earlier importing urea, now it is costing even more to us, even though we are manufacturing it within our own country. And thus it should be focused that the raw materials, if possible, should be taken up from our own country and domestically, so that the cost of production comes down. And finally, some solutions have been given. Firstly, give bigger role to private sector, because the author says that many times it has been seen that the private sector has been more efficient in giving various kinds of services to the people as compared to the public sector, and thus a better and bigger role should be given to the private sector in agriculture as well. Then he says that we should change the system of fertilizer subsidy, and how can that be done is that DBTs, or the direct benefit transfers, or simply direct benefit transfers, simply the subsidies or the amount of money that the government owes to the farmers, they are given directly to the farmers in their bank accounts for buying for various things, and in this case we're talking about for buying fertilizers. Then after that, we should free up the fertilizer market and should not keep it into any kind of major restraints. And then we should let the private sectors compete, which would actually help in bringing down the rates and increasing the competition. And thus, the farmer would be able to avail better and cheaper fertilizers for their field. And finally, we should remove the unnecessary restrictions on the private sector and let it flourish in the field of agriculture as well. With this, we jump towards the last article for the day, which talks about isolating the dissenter. Recently, Sudha Bharadwaj, who is a professor of law at NLU Delhi, has been denied bail, relying upon, now this has to be paid attention, that on what ground has she been denied bail, relying upon prosecution documents, even though they would be inadmissible evidence in the trial. Here, this thing in yellow is to be seen with a critical view, because the bail to this woman, Sudha Bharadwaj, has been denied on the ground of this document, which actually even the court is saying that it might be inadmissible, or the evidence which is not in the position to be admitted as an evidence in the trial. And such document that actually cannot even be used as an evidence in the trial, how can that actually become the ground for not granting a bail to somebody? The court says that it has relied its decision upon the case of Zahur Bakali versus National Investigation Agency. But then again, it has to be pondered that how much is the decision taken in this particular case in the spirit of the law. This case says that under section 43D clause 5 of Unlawful Activities Prevention Act, even on the grounds of mentioned above, it says that if there is a bail application and it has come under section 43D clause 5 of the UAPA Act, then in such a scenario, bail can be denied on even the ground if the prosecution documents are used which are not admissible in nature, and still bail can be denied on that. So here we can simply construe that what is the constitutionality of this very verdict also. Then let's see that what is the validity of this decision. So in the case of Deepak Bhai versus State of Gujarat, the Supreme Court held that any order regarding bail must be based only on the documents that are admissible as evidence during the trial and otherwise not. And this order is against all the precedents. Also, it has been quoted that before this, there was not even a single verdict of Supreme Court wherein the bail could have been denied on the grounds of an evidence of a document which was not even admissible as an evidence. And it has been done only for the first time, and definitely it is. In current case, the documents relied upon by the court are not admissible as an evidence during the trial, and thus it is against the fundamental rights and human rights. With this, we are done with this, and thus we should try to understand that what are the legalities that are attached to bail, and on what grounds can bail be granted, and also on what grounds bail cannot be granted. Finally, let's talk about the news and flash section. Firstly, ND 2020 asteroid, and herein we are sure that you have got the answer to today's MCQ. Firstly, it says that NASA has notified that it will pass close to Earth on July 24th. Basically, ND 2020 is a name given to an asteroid, and it has been named by NASA, and it will pass through the Earth close by the time of July 24th. Also, it has been predicted that it is 50 times bigger than the famous London Eye. This is the picture of London Eye, and we have especially put up this picture so that there is no confusion. We might have seen in various movies also wherein this big merry-go-round wheel has been portrayed, and this is called as the very famous London Eye. And this asteroid ND 2020 is considered predicted to be 50% or 50 times to, or if this is the 100%, then half of it also should be added to it, and 50% bigger than the London Eye. But this is again a thing of relief that it will not be causing any harm to the Earth, and it will just go through or pass close to the Earth. Next, AstraZeneca. AstraZeneca basically is a potential COVID vaccine, though it has not been developed yet, but it is on the verge of being developed and will take some time to be developed. But it is considered to be one of the most potential COVID vaccine, as it has higher efficacy due to the point or due to the fact that it has got in itself killer T cells. This also can be a question from prelims, that killer T cells, as recently seen in news, what are they? Or AstraZeneca, what is AstraZeneca? And thus it has the killer T cells along with the antibodies. Basically, T cells or the killer T cells have the capacity to last longer in a body, and thus they give longer effects. And all in all, in long run, they are more effective than any other kind of vaccine which has only the antibodies, but this has killer T cells along with the antibodies. Thirdly, itolizumab. Basically, itolizumab is one of the newest COVID treatments which has been approved in India. It is actually not a complete treatment to say, but yes, amongst various other drugs that are being used to treat or to bring into normal health various asymptomatic patients as well. So this is one of the newest, newly recognized drugs or newly allowed drugs in India. Then generally it is used for the cure of psoriasis, which is a chronic skin disease. Also, this also can be a prelims question, that generally itolizumab is used for the cure of, so the answer is psoriasis, which is a chronic skin disease, but also it has shown some efficacy in the COVID treatment as well. And finally, community transmission. Let's just see that what actually do we mean by community transmission. When the epidemic becomes so widespread that it becomes difficult to determine the chain of infection. Basically, what happens is that currently, if the number of cases in a particular society are less, it is easier to understand that from where this particular man or woman or person would have caught the virus. For example, when in the initial days, it was construed that the virus was coming from the people who are coming from abroad, it was easier to contain this particular travel, and so it was possible for the authorities to determine the entire chain of infections. But when community transmission starts, then the chain becomes so cumbersome that it is not actually possible to understand that who is giving or who is transmitting the virus to whom. And thus, due to this, the containment becomes very difficult, and India can currently be said to have entered this situation. With this, we will end today's session, and we once again thank you for joining in, and we hope that it was a good fun for you. Do check out the various test prep courses at the LawSikho website, the link of which is there in the description box. Thank you so much.